Three clients, three different situations. All of them thought they had a plan. The first one had rentals inside LLCs. A contractor sued. The LLC held the client was fine because the structure was built correctly and controlled, stayed where it needed to be. The second client wanted to keep things simple, deeded a property directly to his adult son to avoid probate. Unfortunately, the son got sued. The property was now in the son's personal name, exposed to the son's creditors, and there was no way to pull it back. The third one put a valuable property into a trust for asset protection, but the trust was drafted as a completed gift trust, an irrevocable completed gift trust. When the client passed away, his family inherited $1.2 million in capital gains taxes on a property that was worth about $6 million. Taxes that did not have to happen. Three very different approaches, three very different outcomes, and the difference in every case came down to one thing: whether control was preserved or quietly given away. Now, most asset protection videos will tell you to just get an LLC and you'll be fine. Stay with me until the end because I'm going to tell you something about California LLCs that most attorneys will not say on camera. It is the most important thing in this video, and it's the reason why the structure of your plan matters far more than just having one. And Ali Talai, a California asset protection and estate planning attorney and founder of Talai Law Offices, my practice focuses on protecting what real estate investors and high net worth families have spent a lifetime building. Before we get into it, if you want to see how I structure full asset protection plans here in California, including LLC strategies, holding LLCs, trust, irrevocable trust, and layered protection, I walk through all of that in my free asset protection webinar. Registration link is below. And if you go on Instagram and DM me the word webinar, I will send you the link directly right now. All right, let me take you inside each of those three situations. The first client owned several rental properties. He had put each one inside of its own LLC. When a contractor filed a lawsuit over a dispute on one of the properties, the creditor's claim was against that LLC, and only that LLC. The other properties, each held in a separate entities, were completely insulated. My client never lost sleep over it because the structure did exactly what it was supposed to do. He retained control over every decision: who managed the LLC, when distributions came out, how the entity operated. The creditor had no lever to pull. The second client had a property he planned to leave to his adult son eventually, so he figured, why wait? Why not just deed it over and avoid the hassle of probate? I see this, unfortunately, too often. It seemed simple, practical even. What he did not think about was what happens to that property once it is under the son's name and something goes wrong in the son's life. The son got sued, a personal lawsuit completely unrelated to the property, but because the property was titled in the son's name outright, with no LLC, no trust, no structure underneath it, it was exposed to the son's creditors just like any other asset he owned. My client had no legal basis to claw it back. He had permanently transferred the ownership and control with a single signature, with no ability to reverse it if circumstances changed. And they did change. The problem was not that he moved the property. The problem was how he moved it, with nothing in place to preserve control after the transfer. The third client transferred a valuable property into an irrevocable asset protection trust with very low income tax basis. His attorney at the time told them it was for protection, for asset protection, and in one sense, it was, but the trust had been drafted as a completed gift for tax purposes, which meant that when he died, the property inside did not receive a step up in basis. His family inherited the property at the original purchase price from decades ago. The property was worth roughly about $6 million. The original basis was around $800,000. When they went to sell the property, when the children went to sell the property, the combined federal and capital gains taxes came to just over $1.2 million. These are taxes that never had to happen. I want to be precise here because this matters. That outcome is not inevitable with an irrevocable trust. In my practice, I structure these trusts all the time. Most of the time, I draft them as an incomplete transfer for gift tax purposes, which preserves the step up in basis while still delivering genuine asset protection for the client. The tool was not the problem here, it was how it was structured. 3 different approaches, but the common thread is the same in every case. The first client preserved control and the plan worked. The second and third client gave it up, one with a single signature and one through a structure that locked in consequences the client never saw coming. That is what determined the outcome, not the type of strategy, not the label on the document. Control. Let's talk about what creditors actually chase. Most people assume asset protection is fundamentally about ownership, whose name is on the title, whether something is technically in or out of your name. But here is how creditors and their attorneys actually think. They do not just look at who owns the asset. They look at who controls it, who controls the bank account, who decides when money comes out of these bank accounts, who can force a sale, who has the practical ability to make anything happen. Because control is leverage, and leverage is what makes a judgment worth collecting. A judgment without leverage is just a piece of paper. I have seen many times that creditors win in court, but if they cannot force a sale, cannot access an account, cannot compel any decision about the asset, that judgment has very little practical value. Leverage comes from access and control, not from what the title says. This is where real protection lives, not in the label on the ownership, but in what the creditor can actually do once they win. The LLC is the clearest example of control principle in action. When you put a property into an LLC, you did not just change the name on title, you changed the rules. Because an LLC does not only separate ownerships from your personal name, it separates control from access. And that separation is where protection comes from. In California, if a creditor wins a judgment against you personally and tries to go after your LLC's membership interest, their primary remedy against a multi-member LLC is a charging order. A charging order does not give the creditor the right to manage the LLC. It does not give them voting rights. It does not give them the ability to force the sale of the property inside the entity. And this is all assuming that you have the right operating agreement and it's got the right provisions in there. What it gives them is the right to receive distributions, if and when distributions are made. And who decides whether distributions are made? You do, as the manager. That is the key. The creditor is entirely dependent on a decision you control. The creditor won the lawsuit, but now they're waiting on a decision you make. That dynamic fundamentally shifts leverage. I have had cases where creditors with valid judgments settled for a fraction of what they had won, simply because they had no practical path to the assets inside a properly structured LLC. That is not technicality. That is control at work. The same principle applies in estate planning. And this is where the third client story becomes much more common than most people realize. That client is not an outlier. I see versions of his situation regularly, and the most common version involves older revocable living trusts. They sometimes refer to them as AB structure, AB trust. These were trusts that were structured usually before 2011, when the federal estate tax exemption was much lower. The planning made complete sense back then. When the first spouse passed away, the asset would flow into a bypass trust, the B trust, to keep them out of the surviving spouse's taxable estate. But today, the federal estate tax exemption is $15 million per person, $30 million for a family. Those assets sitting in the B trust B trust is for the spouse below the ground. That's how I remembered it. Often do not need the shelter anymore. And here's the cost. When the surviving spouse later passes away, the assets inside of that B trust will not receive a step up in basis. The family, the children, will inherit the properties at the basis at the time the first spouse passed away. And in most cases, they're facing a lot of money, hundreds of thousands of dollars, millions of dollars in capital gains taxes when they go to sell the properties. Taxes that could have been avoided entirely with better design. The assets are locked in a structure that no longer serves them. The family lost the ability to adapt, and the loss of the flexibility has a real dollar amount attached to it. This is also why the drafting of an irrevocable trust matters so much. A trust that is properly structured as an incomplete transfer for gift tax purposes can provide genuine asset protection while still preserving the step up in basis for the heirs. The protection does not have to come at the cost of tax efficiency, but only if the trust is designed and correctly formed from the beginning. The clients who do best in my practice are not chasing the cleanest looking ownership structure on paper. They are preserving decision-making power. Good control means control over timing, control over distributions, the ability to adjust when circumstances change, whether that is a new lawsuit, a shifting tax environment, or a family dynamic, or a change in the law. And this is exactly why one-size-fits-all planning fails. People are told, just put it in an LLC, just put it in a trust, just get it out of your name. Those are all tools. They can be powerful tools, but tools are not strategies. Used correctly, these structures preserve control. Used incorrectly, they can eliminate it. Asset protection is not about disappearing, it's about positioning. You want to be in the place where decisions are not forced, outcomes are not locked in, and leverage stays on your side. That is true when a lawsuit lands, it is true in tax planning, and it is especially true at death when your family is the one making decisions under pressure and the plan either gives them options or it doesn't. Now, here's what I promised you at the beginning, and I want to be straight with you because this is the thing most asset protection videos, at least the one I have seen, will never say out loud. The California LLC standing alone is the starting point. It is not a complete plan. Here is why. California is not a strong charging order state. Yes, a charging order is the primary remedy, and it is powerful, but under California law, a court can go further and order a foreclosure sale of your membership interests. Courts in California do use this remedy, and beyond that, experienced creditors' attorneys know how to pressure equitable theories in California, reverse veil piercing, constructive trust, and alter ego claims that allow them to attack the LLC itself, not just your interest in it. Those are real tools, and if your LLC is a single member entity with no clean records, no separate operations, no real structure behind it, those theories become much easier to pursue. This is exactly why the first client's plan held. It wasn't just that he had LLCs. It was how they were built and what sat behind them. A Wyoming LLC sitting above your California holdings changes the equation significantly. Wyoming has one of the strongest charging order statutes in the country. It is the exclusive remedy with no foreclosure option available to creditors. The creditor is locked into waiting on distribution. That is a fundamentally different position than what California law offers. And when you add a properly drafted asset protection trust on top of that, structured as an incomplete gift so it preserves control and the step up in basis, you have removed the equitable theories entirely. There is no alter ego argument. There's no reverse veil piercing. The asset is inside a trust, a structure that creditors cannot reach through the same tools they use against individuals. Each layer removes a lever the creditor would otherwise have Control is preserved at every level. That is what makes the plan hold, not just in theory, but when a creditor and their attorneys are sitting across the table calculating whether it's worth coming after you. This is the difference between having a plan and having the right plan. Key takeaway: ownership is visible, control is decisive, and the right structure delivers both. Getting your name off your assets matters. It matters enormously. A plaintiff's attorney doing a public record search should not be able to find you immediately and decide if you are worth pursuing. Privacy planning, keeping your name off title through land trust, LLCs, and properly structured entities is a core part of every plan I build. But here's a distinction that the second client missed. Getting your name off the asset is not the same as giving up control. A land trust with you as the beneficiary gets your name off the deed and keeps you in control. An LLC where you are the manager gets your name off the title, but you get to keep control and management. The right vehicle does both jobs at the same time. What the second client did was transfer title with nothing underneath it. No trust, no LLC, no retained control. His name came off the title, but so did every lever he had. That is not privacy planning. That is just giving the property away. The best asset protection plans accomplish all three things together. Your name is off the assets for privacy, control is retained through the right structure, and the plan is built so that a creditor calculating their options decides that coming after you is not worth it. That is what a complete asset protection looks like. If you want to see exactly how I built these layered structures for real estate investors here in California, including how the Wyoming LLC fits above the California holdings and how the trust layer completes the plan, that is exactly what I walk through in my free asset protection webinar. The link is below and it's in the description as well. And if you are on Instagram, or if you go to Instagram now and DM me the word webinar, I will send it to you directly. I look forward to seeing you there.